Good afternoon and welcome to day 2 of the Business Exchange Southwest Charity Conference and Expo 2021 in partnership with Milstead Langdon Accountants and Stone King Law. I'm delighted to have with us today Tim Rutherford from Stone King, who is partner and head of charity and social enterprise at the firm. Good afternoon, Tim. The stage is yours. I will exit and leave you to talk about the Charities Bill and what we need to know.
Thank you. Well, good afternoon, everybody. You'll have probably seen in the sector press that there is currently a new Charities Bill working its way through Parliament, which will hopefully come into force in the next few months. And the purpose really of today's session is simply to give you a very brief introduction to the main provisions of the bill so that you understand what it's intended to achieve. So first of all, thinking about the background to the bill, the last substantive revision of charity legislation was actually the Charities Act 2006, which then in 2011 was consolidated with some other legislation into the Charities Act 2011, which remains the primary piece of legislation for charities today. And then in 2012, Lord Hodgson concluded his review, which was actually a 5-year review of the Charities Act 2006. And he published a report making various recommendations about how charity law could be improved. And following that report, there was an initial consultation by the Law Commission in relation to social investments and the Charity Commission's powers. And that led to the Charities Protection and Social Investment Act 2016, which amended the 2011 Act. And then in 2015, the Law Commission started a much wider consultation on the remaining issues. And they published in 2017 their report, which was called Technical Issues in Charity Law, and that was put forward for consideration by the government. There was then an incredibly long pause, not because there was anything controversial in that report, but simply because the government's been preoccupied with Brexit, pandemics, and other things. And then out of the blue, as a sort of surprise, earlier this year, the government suddenly published its response to the Law Commission's recommendations. And they've accepted 36 out of the 43 proposals that were put forward. And as a result of this, the Charities Bill was introduced in the Queen's speech in May this year, and it's already had several readings in the House of Lords. So it's been a long time coming, but does the bill actually make any significant changes to charity law? And what does it actually mean for you? Well, in the explanatory notes to the bill, the government said, charities legislation is commonly perceived as being complicated, uncertain, and in place unduly burdensome. This can delay or prevent a charity's activities, discourage people from volunteering to become trustees, and force charities to obtain expensive legal advice. It also hinders the Charity Commission in its regulation of the sector. So the government went on to say that if the bill was enacted, the impact of these changes will significantly improve the efficiency of the sector, release more funds for use on charitable purposes rather than administration, and reduce unnecessary and overly bureaucratic regulation that not only increases the sector's costs, but is also a factor in discouraging people from volunteering to become trustees. But I think that that's probably slightly aspirational. The majority of the bill really just makes quite technical adjustments to charity law and regulation, and a lot of it is unlikely to change how you operate on a day-to-day basis. But the aim of this session is to give you an overview of what is in the bill, what it might mean for you, and to think of some areas that you might want to look at in the future. And at the end, there'll be plenty of time for questions. Now, the bill itself is relatively short. It runs to 41 clauses over 7 parts, and there are 2 schedules. And I'm going to look at the main section, so I'm not going to deal with every single clause because some of them are simply boilerplate or repeal of other bits of legislation. So The first part of the Act deals with purposes, powers, and governing documents. And to start with, clauses 1 to 5 of the bill seek to align the legislation relating to the amendment by charities of their governing documents. Currently, the process to amend a governing document and what is required by way of Charity Commission consent varies very much depending upon how your charity is structured. So if your charity is constituted as a company limited by guarantee, then amendments to your governing document, i.e. your Articles of Association, are made by passing a special resolution passed by a 75% majority of the members of the company. Now, companies can pretty much amend their articles in an unrestricted way, save for the fact that Section 198 of the Charities Act provides that there are 3 areas where you need the Commission's consent before you can make an amendment. And these are amendments to the objects of the charity, what it was set up to do, amendments to any provisions that benefit trustees, and any amendments to the dissolution clause that deals with how the assets of the charity are distributed if the charity is wound up. Now, one technical area that's always caused problems for charitable companies is due to a difference between charity law and company law, and it's in relation to the amendment of a charity's objects. So the current wording in the Act says you need consent to an amendment of the company's Articles of Association, adding, removing, or altering a statement of the company's objects. And the difficulty this has always raised is that if you want to amend the wording of your objects clause without actually changing the purposes, you need the Commission's consent. So in the silliest of cases, if, for example, you were updating the Articles of Association for your charitable company and you wanted to capitalise the T on the word trustee throughout the articles, and that word trustee is used in the objects clause, then unfortunately capitalising the T would be a regulated amendment. And if you didn't get consent to that and you'd made wholesale amendments to the articles, then your amendments could fail. And we've also had a number of cases where clients have wanted to change and update terminology. So maybe in the past, the articles talked about members of council and the client wanted to change it to say trustee. And because the word appeared in the objects, clients have taken the view they didn't want to make the change because they didn't want to go through the process of getting Charity Commission consent. So the proposed amendment here is to actually change the legislation to say you will only need consent from the Commission if the change actually alters the charitable purposes of the company. So thinking back to the example of capitalising the T on trustee, that wouldn't require consent because it's not changing the purposes. However, if you, for example, wanted to change the area of benefit, say maybe from the City of Bath to City of Bath and surrounding area, that would be the type of amendment that would require consent. So the advantage is you can update your wording, you can modernise it, you can have a slight change in the wording of your objects without necessarily any longer needing Charity Commission consent. And that would give a bit more flexibility and will also mean that the provisions are very consistent with those that apply to charitable incorporated organisations. In addition, it's always been the case that the legislation doesn't provide any guidance as to what factors the Commission need to consider when they're faced with a request by a company to make a regulated change to the objects. And that's often led to confusion and inconsistent decisions being taken by the Commission. So the bill is proposing to introduce a statutory test setting out the factors that the Commission has actually got to have regard to when faced with an application. And the first one is that the purposes of the company when it was established, if and so far as they can be ascertained. Secondly, looking at the desirability of securing that the purposes of the company are, so far as reasonably practicable, similar to the purposes that are being altered. And then finally, being sure that the purposes are suitable and effective in light of current social and economic circumstances. And that hopefully will make the position much clearer, and it's similar to the situation that applies for unincorporated charities. And in addition, it perhaps gives the Commission slightly less flexibility to consider issues outside of those factors. So hopefully there'll be much greater consistency. It's also worth noting that clause 37 of the bill would give the Commission the power to give public notice of proposed amendments before it actually gives consent, and it might start to do that if it feels it's something that deserves wider public consultation. So that's companies. The second section deals with amendments to the constitution of CIOs. Now, this again tries to align the position more to the position that applies for charitable companies, and it does that in two ways. First of all, it introduces exactly the same test for the Charity Commission when considering regulated alterations to the charitable purposes, as we've just looked at for companies, so there's a level playing field. It also would provide that amendments to a CIO's constitution, which aren't regulated amendments, would take effect immediately, which is the same case as for a company, as opposed to the current position where they only take effect when they're registered at the Commission. Now, the position in relation to regulated amendments would stay the same, and they would only take effect when registered with the Commission. And again, clause 37 also introduces the idea that the Commission could give public notice of amendments. So essentially, if the bill comes in, the provisions for CIOs and companies will be virtually identical, and some of the technicalities would have been taken away. Now, the provisions regulating the amendment of the governing documents of unincorporated charities are actually fairly complex, and different rules apply depending upon the size of the charity, and in many cases you need to get a scheme from the Charity Commission, which involves some quite complicated powers of the Commission and actually being able to make out a case that falls within the grounds for making a scheme. Now, currently, all unincorporated charities already have a power under Section 280 of the Charities Act to make what are known as administrative amendments. So things like the number of trustees you have, how meetings are held, and so on. But the ability to amend your purposes or change restrictions relating to the spending of capital or altering your powers are very different and can depend upon the size of the charity, and quite often you need a Charity Commission scheme. And the schemes can be complex because you also sometimes have to go out to public consultation. Now, the new provisions in the bill would provide a much wider power for all unincorporated charities, so that's trusts, unincorporated associations, charities governed by schemes, will trusts, and so on, to amend any provision in a governing document. And that new power would not be able to be modified or excluded in the governing document. But the power would only be able to be used if the trustees are satisfied that it is in the interests of the charity that the provisions governing the charity should be amended. And in addition, it would need to either be approved by 75% of the trustees or by 50% of the trustees and 75% of the membership if there's a separate membership. So that would make the threshold very similar to the threshold for companies and CIOs. And again, similar to companies and CIOs, there would instead be a series of amendments that would require Charity Commission prior consent. So instead of requiring the Commission to agree to all the changes, it would simply be this narrower pot of regulated amendments. So those include anything that alters the purposes of the charity, anything that alters a provision directing the application of the charity's property on dissolution, and anything that provides authorization for a benefit to be obtained by trustees, the members, or anyone connected to the charity. So that standardizes the position in the same way as for companies and CIOs. But in addition, it would also be a regulated amendment if you wanted to alter a restriction that affected permanent endowment, or which was going to regulate anything that related to the consent of a third party, either an individual or an office holder. So, for example, your trustee might say that the bishop of the local diocese has the ability to appoint one or two trustees. You might want to remove that requirement, but that would become a regulated amendment and you wouldn't be able to make it without the Commission's consent, unless the individual themselves consented or if, for example, the office that was referred to no longer existed. Now, in addition, if the amendment is one to the charity's purposes, then the Commission would now be faced with a test of exactly the same factors as we looked at for companies and CIOs. So effectively, there's a complete consistency of approach. And if the power is used, the amendments would take effect on the date that the resolution is passed, or if relevant, the date when the Commission has given consent for any regulated alteration. So overall, in relation to unincorporated charities, it's going to be much easier to make changes to your governing document, and you'll be able to do a lot more of it without having to involve the Charity Commission. And in addition, those areas where you do have to involve the Commission, such as amending your purposes, the test is actually slightly easier. So for all charities, if you've thought about amending your governing document in recent years and have been put off because of some of the technical issues, you might want to revisit whether things have now changed. Now, clauses 4 and 5 of the bill make similar changes in relation to amendments by Royal Charter charities and charities created by statute, but because those don't involve many charities, I'm not going to look at those. So the next area the bill deals with is what's known as the Seaprey Powers, and these are most often relevant to a situation where a charity is fundraising for a particular purpose. So as you may be aware, if you were going out to fundraise for a particular purpose, maybe you're a medical charity looking to acquire a particular piece of kit and you put forward an appeal to raise the money to buy that piece of kit. If you fail to actually raise enough money, then you currently have what's known as an initial failure, in which case you actually have to return the money to the people who've given the donations. And there are very complicated rules about how you do that. On the other hand, if you raise too much money, you have what's known as a subsequent failure. And there are complicated rules about deciding how you can use those surplus funds and whether or not you have to return any of them. Now, most charities aren't very familiar with these rules and tend to only find out about them when it's too late and something's gone wrong with an appeal. And that's why if you look at the Commission's own fundraising guidance, it always says that you should include some standing wording saying that it's clear that if you fail to raise enough money or you raise too much money, then you can use the monies raised for the general purposes of the charity. But quite often people forget to do that. And if you find yourself in this position where you've had an initial failure or a subsequent failure, the current rules are very outdated and they don't take into account methods of communication like the internet or social media and email. And the way that you have to go around contacting donors is through putting adverts in newspapers or on local notice boards and doing things that probably are completely impractical. So the new provisions allow a much wider range of donations that have been given for particular purposes to actually be applied Seaprey without having to go through the process of returning them to donors. And the proposed position sets out 4 cases when this would apply. So money wouldn't have to be returned firstly if the Commission agrees it would be unreasonable to incur the expense to return the donation, or if it would be unreasonable for the donors to expect the donation to be returned. So you can just agree with the Commission that perhaps it was a small fundraising appeal, not much involved, and therefore it just isn't really reasonable to go back to everybody. The biggest change is that if the donation is a single gift of £120 or less, and during the year you're satisfied that the total amount somebody is likely to donate to you is less than £120, then unless the donor has specifically said when making the donation that the funds must be returned if the particular purpose fails, you don't have to return it to them. But that may mean that you've probably got to keep slightly better records maybe of donations that are given for particular projects. The third case is where you can't find the donor or you can't identify them after making reasonable inquiries. Now, currently, this is the bit where you have to go and put adverts in local newspapers, put things up on notice boards, try and actually get hold of all the people who donated money. But now you'll be able to say to the Commission, can we just agree with you that we perhaps put an advert on the internet or on social media and that that's sufficient? And hopefully the Commission would agree with that. The final category is that, as currently, you can treat donors as being unidentifiable if they've basically given cash into a bucket or if it's money relating to lotteries, competitions, and so on. So overall, that's likely to make it much easier to work out which donations have to be returned and which don't. And it will give you greater flexibility to actually deal with things if something goes wrong on your appeal. Now, currently, once you've gone through all the steps of returning funds to donors and you're left with a pot of money, maybe where donors can't be identified or they've agreed you can hold on to the donation, you then have to apply the funds to Seaprey, which means for similar purposes within the charity. And that requires you currently to get a Charity Commission scheme to redirect the use of the funds. And that equally can be a complex, difficult procedure. Well, the bill is proposing in clause 7 that actually, rather than having to go to the Commission for a scheme, the trustees will be able to pass a resolution themselves to decide the purposes for which those funds should be used. Now, if the funds are less than £1,000, you can simply pass the resolution yourself and that's it. If the funds are over £1,000, you still have to file the resolution with the Commission, and it only takes effect when they give consent. But the Commission doesn't have to go through this process of putting in place a scheme. The next section of the bill deals with permanent endowment. And as you will know, if you have permanent endowment, that's essentially funds where you can spend the income generated from the capital, but you can't spend the capital itself. Well, there are currently some technical issues with how the term is used in the Charities Act 2011, and that's caused a lot of interest amongst lawyers and academics. And one of the things the bill is going to do is slightly change the definition, but that's not going to really have a practical impact for you. But what's more interesting is currently there are powers for trustees to pass resolutions to de-restrict permanent endowment to enable them to spend capital. But they depend upon the size and income of the charity. So if you have a permanent endowment fund that's less than £10,000, or the annual income on the fund is less than £1,000, you can pass a resolution to de-restrict it and spend that capital without involving the Commission. And in all other cases, you need the Commission's consent. Now, what is proposed in clause 10 of the bill is to remove that income threshold and to simply look at the capital level of the fund. And it will then be possible for trustees where the fund is less than £25,000 to simply pass the resolution without having to go to the Commission. And in all other cases, it will be necessary to go to the Commission still for consent. Now, on the one hand, that's good because it's going to open this up to more funds because the difference between 10,000 and 25,000 is quite significant. But the one impact it may have for some charities is that in recent years, we've seen that you can, for example, have a fund of £100,000, but the income in the last financial year might have been less than £1,000, which meant you were able to de-restrict it without involving the Charity Commission. So if you have got those sorts of large funds where you're getting virtually no income and you have been thinking about de-restricting them, you might want to do it now before this change happens. At the same time, currently, when you put your application into the Commission, they have 3 months to decide whether or not to agree with it. That's going to be shortened to 60 days, which again sounds good. But the bill includes a provision for the Charity Commission to effectively stop the 60-day timetable working if either they ask you to give public notice of the resolution or they request more information. So on the one hand, it seems like a shorter time period, but in fact, I think the Commission would just extend it. Now, the next area that affects permanent endowment is in relation to borrowing. And currently, there is no ability to borrow from your permanent endowment funds. The only way to do that is if you get an order from the Charity Commission. And sometimes it's preferable to actually borrow that capital rather than de-restrict the permanent endowment and spend it. And that's because once you've de-restricted permanent endowment, you can't restrict it again in the future. You can't create permanent endowment yourself. So occasionally, if charities want to preserve their permanent endowment but make some use of the capital, they'll borrow it in the short term with a Charity Commission order. Now, those orders normally would require that the funds are recouped and repaid over a period of time. So in order to make the process less bureaucratic, the bill is including a power to enable trustees to borrow from their permanent endowment funds. And you would be able to exercise the power if you're satisfied that it's expedient for the amount to be borrowed, taking into account the purposes of the fund and the overall purposes of the charity. Now, the amount that you could borrow would be limited to the permitted amount, which is effectively 25%. And you have to put in place arrangements for the funds to be repaid over a 20-year period. Now, the provisions relating to the permitted amount vary to take into account previous borrowing. So if in year one you borrowed 20% of your permanent endowment, until that had been repaid, you could only borrow a further 5%. What you won't be able to do is borrow further funds from your permanent endowment to repay your previous borrowings from permanent endowment. And it's also worth noting that this wouldn't apply to what's known as functional permanent endowment. So if you've got, for example, a property that you hold on trust to be used for specific purposes, and it's therefore functional permanent endowment, this power wouldn't enable you to borrow that property. Now, in addition, when you come to repaying the funds, normally you can't create permanent endowment yourself. So the provisions actually allow you to repay a little bit extra, if you want to take into account the amount that that capital sum would have appreciated over the period if you hadn't borrowed it. And that is quite closely regulated by the bill, and it sets out the parameters that would apply as to how much you can actually overpay. And obviously, whatever you repay does become part of the permanent endowment. Now, if the trustees in future form the view that they were unable to repay the sum that had been borrowed, there's also a provision that enables them to go back to the Commission for directions, which might be to allow repayment over a longer period, or actually might be to say, well, there's no requirement to repay at all. So overall, this is going to give those of you with permanent endowment slightly more flexibility to use that capital without always having to go to the Charity Commission. And it'll be interesting to see how many charities start to use these provisions. The next section of the Act deals with ex gratia payments. Now, an ex gratia payment arises in a situation where the trustees of a charity feel that in a particular set of circumstances, they have a moral obligation to make a payment to a third party or to waive their right to property that would then go to the third party, but they have no legal obligation to make that payment. Now, if trustees don't have a legal obligation to make a payment or to waive their entitlement to something, then they can only do this by persuading the Charity Commission to make an order under Section 106 of the Charities Act. Now, the two common situations where this tends to arise are firstly where a charity perhaps receives a windfall legacy from someone, and the person was perhaps either in the process of about to amend their will to provide some of it for their family, or maybe didn't make any provision for their family because they didn't think that they were necessarily going to die until the family were self-sufficient. And occasionally, families will come to the charity and say, you're getting this windfall, actually, we need that money, would you agree to let us have it? And currently, if there's no legal obligation to do that, the only way to do that would be as an ex gratia payment. The second scenario is sometimes when a charity wants to give a non-contractual payment to an employee, perhaps as a thank you for long service on retirement or something like that. And again, it's a non-contractual payment, so there's no legal obligation to do it. Currently, those types of arrangements would require a Charity Commission order. The new provisions would give slight flexibility to enable trustees to make payments up to a certain level without requiring Commission consent. And that level would be determined by the charity's income in the previous financial year. and the threshold is going to apply per payment, not as a total per year. As currently, trustees would still have to be satisfied that there's a moral obligation to make the payment and that actually there's no other legal basis for making it. But in terms of the thresholds, if the charity's income is up to £25,000, then you can make an ex gratia payment up to £1,000. If it's between 25,000 and 250, you can do it up to 2,500. If it's between 250,000 and £1 million, it could be up to 10,000. And anything where the charity's income is above £1 million will enable you to make ex gratia payments up to £20,000. Now, in addition, the bill makes the test an objective test as opposed to a subjective test. So what this means is, rather than the trustees having to believe that they are under a moral obligation to make the payment, the test will be whether the trustees could reasonably be regarded as considering themselves as being under a moral obligation. And that probably seems a completely insignificant amendment. But what it actually means is that trustees can delegate the decisions on this to members of staff as to whether or not to make an ex gratia payment. And that will be helpful if you're a charity that receives a lot of legacies, because you may have a legacy officer who you would like to delegate that decision-making process to. But it does remain the case that simply because you don't have a legal obligation to make the payment, you must still consider the moral obligation, and that power should only be exercised in appropriate circumstances. So simply because you might be able to do it doesn't mean that you have to do it. Now, the next part of the bill deals with charity land and will be helpful for those of you that deal with disposals of land on a regular basis. Now, this is one of the areas where the Law Commission made a number of recommendations, in particular in relation to land used by trading subsidiaries, that the government didn't accept, which is unfortunate, but those changes that they are proposing would at least be helpful. So, as you'll know, Part 7 of the Charities Act regulates disposal by charities of land and imposes restrictions to ensure that you get the best terms possible when disposing of land, save in certain prescribed circumstances. And one area that's occasionally caused problems in the past is where one charity has owned land jointly with others. For example, a piece of land might be left in the residuary estate of a will, and for various reasons it may be more sensible from a tax perspective to transfer that land as land to the residuary beneficiaries for them to sell it. If land ends up being owned by several charities, then currently, in order to dispose of that, each individual charity needs to get their own surveyor's report and follow the advice from the surveyor. In addition, if the land is owned by the charity with non-charities, maybe members of the testator's family, the charity still has to get a report and follow the report. The proposal under the bill is that that would change. You would only have to follow the rules on restrictions relating to charities if the land was owned solely by one charity. In addition, there have been issues when a charity has, for example, gone into liquidation, and whether or not the liquidator can dispose of the charity's property, or whether the trustees first have to go through the process with surveyors and then make the decision. And the bill is making it very clear that no, if a charity's gone into liquidation or administration, then it's the role of the liquidator or the administrator to deal with disposal of charity property. There's also going to be some changes around charity to charity transfers, because it's always been the case that you were exempt from the regulations in the current Act if you make a transfer from one charity to another, which is furthering the purposes of the first charity and is being done perhaps not at the best value. Now, the issue has always been whether, if price is a motivating factor in those transactions, the restriction does or does not apply. And the bill is going to clarify and make it very clear that if the restriction applies unless price is not the motivating factor for doing the disposal. So, for example, if Charity A and Charity B have similar purposes, and Charity A wants to transfer land to Charity B for a nominal value, And the reason for doing that is because Charity B will make better use of the land, or perhaps effectively as pretty much a change of trustee, then the Part 7 restrictions wouldn't apply, and that would be an exempt charity to charity transfer. However, if the land is being transferred for value, and that's a relevant factor in the transaction, then even if it's at a discount, those restrictions still apply. So for example, Charity A has a piece of land worth 100,000, but wants to sell it to Charity B for 80,000 because it needs to get some value out of the land, then that would not be classed as an exempt charity to charity transfer. That wouldn't stop it being done at a discount, but the trustees would have to satisfy that that was the best interests of the charity. In addition, if it's a straightforward sale from Charity A to Charity B at market value, then that will have to follow the Part 7 restrictions, and you'll need to get a surveyor's report. Sometimes in the past, people have tried to argue that simply because it was charity to charity, it was exempt. In addition, in the current arrangements, you are required on a disposal to advertise the disposal in the method set out in your surveyor's report, and sometimes that's a bit unhelpful. So the bill actually provides that whilst trustees will still have to consider the surveyor's advice on advertising, you don't actually have to follow that advice if you don't think that it's necessary. One of the bigger changes is going to be around the range of individuals who can provide that necessary advice. And the bill is moving away from using just surveyors to using designated advisors. And it's thought that that might, for example, include fellows of the National Association of Estate Agents and the like. But there is going to have to be secondary legislation in due course to confirm what's meant by a designated advisor. But what this will probably mean is if, for example, you're disposing of a 3-bedroomed house, rather than having to get a complicated surveyor's report, you may be able to just get something slightly more simple from an estate agent. The bill's also clarifying that that surveyor's advice can actually be given by charity trustees, officers of the charity, and even employees employed by the charity during the course of their employment, because there was always a question previously as to whether that was possible. In addition, currently, if you wanted to give a short-term tenancy to an employee, you would be forced to do that either as a license or a service occupancy agreement, because the employee would be considered a connected person, and therefore entering into a tenancy would require Charity Commission consent. However, the bill is proposing that in those circumstances, actually an employee would not be considered a connected person, and therefore, provided you went through the proper Charities Act disposal process, you could give a tenancy to an employee without having to go to the Commission for consent. And that's probably going to be helpful to charities who've got some accommodation available for employees, but don't necessarily want to link that occupation to employment. Part 3 of the bill deals with charity names, and currently the Commission only has the power to require a charity to change its formal name and has no power to stop it using a working name. So for example, Comic Relief is not actually the formal name of the charity that runs Comic Relief. The formal name is Charity Projects, and it's known as Comic Relief as a working name. Currently, the Commission couldn't force it to change that name, but under the bill, it would have a new power to enable it to stop charities using working names in the same way as it can require a charity to change a formal name. And that's normally around when a name is being used that's misleading or perhaps very similar to another charity. In addition, currently, the Commission can only change names, require names to be changed if they do it during 12 months after registration, but that time limit is going to be removed. And an additional area is that the Commission would be given power to require an exempt charity to change its name. Currently, those charities that are exempt from being on the Charity Commission register can't be forced by the Commission to change their names. The next part of the bill, Part 4, deals with charity trustees, and there are some quite helpful new proposals here. The first one is Clause 29, which would give the Commission the ability to resolve uncertainties or defects in the appointment or election of charity trustees. If there's any uncertainty as to whether somebody's been validly appointed or validly elected, then the Commission can ratify that appointment subject to the consent of the individual in relation to anything done after the date of the order. And that will avoid the need to go through another election or appointment process. So, for example, maybe you've elected trustees over Zoom and then somebody has raised a question as to whether actually under your governing document you could do that. If this power existed, the Commission could say, well, you didn't actually have power to do that, but we're going to ratify the election. Or if there's any doubt over maybe the office holder who makes an appointment, maybe it was the parish councillors of a particular parish that's slightly restructured, and therefore there's a question as to who actually makes the appointment process. Again, the Commission can get involved in ratifying things. In addition, we all know that trustees are not allowed to benefit as a result of their position of being a trustee. And therefore the starting position has always been that trustees can't be paid to provide goods and services to their charity. But under section 185 of the Charities Act 2011, it's always been permitted in certain circumstances for trustees to be paid for the provision of services. So that's services for doing things other than acting as trustee in certain approved circumstances. But there's always been an oddity that this doesn't apply to goods. So under the current provisions, it would be possible for a charity to pay a trustee to come and decorate its premises, but not to pay the trustee separately for the paint that was going to be used to decorate the premises. And what the new provisions are going to do are effectively extend the permitted circumstances to cover services and goods. What they don't do is make any change to the fact that trustees cannot be paid for the provision of services as a trustee or be paid for being an employee. Now, the Commission has, of course, always had the power to authorise a charity to pay its trustees or to receive a benefit from the charity. So, for example, it's quite common to obtain Charity Commission consent to appoint a trustee as an employee in certain circumstances, or maybe to employ a person who's connected to a trustee. Where things have been difficult in the past is if perhaps a charity has done that, not realising it needed Commission's consent, then at a later date realised it needed consent and went to the Commission to get consent, the Commission has no power to retrospectively authorise the benefits. So if perhaps it took a year for the charity to realise it needed consent to employ one of the trustees as an employee, then technically, even if the Commission does then give consent, that individual is required to repay all of the salary that they've received over the previous year as an unauthorised benefit. Now, at the moment, if you're in that situation, you're really left with no option but to either demand repayment or go to the court to get what's known as an order for equitable remuneration, or to try and persuade the Commission that it would be disproportionate to issue proceedings to demand the repayment of the money. So it's going to be quite helpful that the Commission would actually have the power to rectify this retrospectively. But the Commission does have to be satisfied under the test that's set out in the bill that it would be inequitable for the person not to benefit. And in addition, they have to decide whether remunerating the person or allowing them to keep the benefit would encourage breaches of trust or breaches of duty by persons in their capacity as charity trustees. So I don't think they'll be doing it on a sort of day-by-day basis. Finally, one of the things the bill does is provides that all body corporates that are charities who are acting as a trustee of a separate charitable trust will automatically have trust corporation status. And again, that's a technical point, but it is quite helpful because corporate charities, if they want to hold something as permanent endowment, need to hold it on a separate trust. But as a matter of trust law, in order to be able to be a valid trustee of land, you need, if you're going to be a sole trustee, to have trust corporation status. And the only way to get that was by a Charity Commission scheme or by applying to the Ministry of Justice. But now that's not going to be needed, so it's going to be much easier for corporate charities to hold things on trust. Part 5 of the bill deals with charity mergers. Now, one of the big issues on mergers and indeed incorporations when you've gone from a charitable trust, maybe to a company or a CIO, is what to do with the old charity. And in particular, because people have been concerned about legacy gifts to the old charity. Now, it's always been intended since 2006 that if following a merger or an incorporation, you entered that onto what's known as the Register of Mergers, then any gifts in the future to the old charity would automatically be redirected to the new merged charity. And in the main, that's really been successful. The problem has come about because of the way that the legislation is worded, and the fact that if the will itself says, I leave my money to charity A, provided that charity A still continues to exist at the date of my death, then the Register of Mergers doesn't catch that legacy. And as a result of that, lots of charities, when they've merged or incorporated, have kept the shell of the old charity on the Charity Commission register, so that if any legacies come in those circumstances, they don't get lost. And that's led to a lot of these shell charities clogging up the register. So what the bill is proposing to do is to sort out that anomaly and provide that the gift will go to the new charity, even if the old charity has ceased to exist. So technically, the old charity will be deemed to still exist for those purposes. So I think we're going to see quite a few charities using that as an opportunity to get rid of shell charities that have been left behind. But just a note of caution, the only way you can do that is not simply to go in and remove it from the register, but you do need to go through the Register of Mergers process in order that it's actually then onto the Register of Mergers so that the legislation picks it up. So I think that we will see a few charities taking advantage of that. Now, parts 6 and 7 of the bill aren't that interesting. They really just deal with repeals of various bits and other bits of general legislation. So I'm not going to look at those in any detail. In terms of the timetable, well, the bill is following the special bill committee procedure for law commission bills, which was introduced a few years ago, which enables it to be fast-tracked through Parliament on the basis that it's considered to be uncontroversial. What that also means, though, is that if amendments come up during the process, if they are not directly related to implementing the Law Commission's recommendations, they will be resisted by the government. However, if somebody puts forward a stunningly good amendment and the government think, well, actually, that's a good idea, they would then have to take it off the special bills process and it would go into a much longer drawn out process. But our understanding at the moment is that it's sticking on the Special Bills Committee procedure and that we could be looking at seeing the bill come into force early next year and then some Charity Commission coming out on the back of it. So overall, the bill does make some quite helpful changes that do improve charity law, but they're unlikely to be something that you're going to be dipping into on a daily basis. But they do perhaps help reduce some of the bureaucracy and administration. So I'm now going to take any questions if we have any, and those are dealt with through the chat function. I'm just having a look. So at the moment, I don't think we have any questions. So we'll just wait a second and see if...
Hi, Tim. I did see a question pop into the chat, and it was, do we think that lots of charities and not-for-profits are going to get tripped up as a result of these changes, and that they really do need to have a think now before things come into force?
I think the straightforward answer is no, because most of these changes are things that when somebody comes to do it, like amend their governing documents or think about wanting to spend their permanent endowment, it is the area where normally you would be looking for advice or going and looking at the Charity Commission's guidance to see what you can and can't do. And at that stage, you'll realise that, yes, there is something here that we can do under the bill. Very few of the things in here are things that people will be necessarily doing themselves on a sort of daily basis or thinking about. But equally, things like ex gratia payments, people should look at that because they might want to make use of that. And the bits around the charity land, if you're disposing of land on a regular basis, you'd probably want to be familiar with that area.
Mhm. Okay, well, thank you very much for your time this afternoon and for your insight into the Charities Bill and the changes that are coming into force. So if you do have any questions for Tim and you're watching this on Catch Up, please do connect with Tim Rutherford on LinkedIn. And as you can see, his email address and telephone number is on screen as well. So thank you, Tim.
Thank you.
Take care.